sure, we'll have it with no audio for now to see if the video works. Yeah, if anything, I'll give you another call. We're fine.
You got a copy of the?
Okay. All right, we're live. Give me just a moment so I can get you the sign-in sheets.
I don't, I will.
We can recite I have an opening statement.
You got it.
Are we good? Okay. Good morning, everyone. Today is July 16th, and the time is 9:03. The special magistrates for the town of Pembroke Park will now begin. Guys, I thank you so much for your patience, and I thank you for your indulgence. I will be reading an opening statement, so please indulge me. Ladies and gentlemen, welcome, and thank you for being here today. Please turn off any cellular telephones to avoid interrupting these proceedings. There are no weapons of any kind permitted in these chambers. Can everyone hear me? That sounds better to me. Okay. And all issues that may come before the special master, we ask that everyone show mutual respect for take two. In all matters and all issues that may come before the special master. We ask that everyone show mutual respect for one another by listening quietly to each person speaking, and that everyone refrain from any clapping, heckling, or verbal outbursts in favor or opposition to a speaker. These are hearings conducted by a special master, the purpose of which is to give any alleged violators the opportunity in a quasi-judicial manner, and I am the special master assigned to hear today's cases. My name is Andre McKinney. My responsibility is to act much like a judge in court, and that is to hear cases presented by the code enforcement officer and to hear contradictory arguments presented by the alleged violators. These hearings are open to the public. It is required that all persons who testify as to the facts of the case be placed under oath, including the code enforcement officer. These hearings will not be conducted in accordance with the formal rules relating to evidence and witness. Any relevant evidence will be admitted if I find it to be competent and reliable, regardless of the existence of any common law or statutory rule to the contrary. All documentary evidence must be submitted for placement in the hearing file. No documentary evidence will be considered unless the alleged violator or code enforcement officer submits a copy for the hearing file. Each party shall have the right to call and examine witnesses, to introduce exhibits, to cross-examine opposing witnesses on any matter relevant to the issues, even though that matter was not covered in the direct examination, to impeach any witness, regardless of which party first called him or her to testify, and to rebut the evidence against him or her. It is my responsibility to make findings of fact based on the evidence of record. The fact-finding determinations of a special master are limited to whether the alleged violation occurred, and, if so, whether the named individual in the civil violation notice can be held responsible for that violation. I may also modify the decision of the code enforcement officer as to the time for correction contained in the civil violation notice, even though said time is presumed authority to assess and order the payments of civil penalties, to issue orders having the force of law to command whatever steps are necessary to bring a violation into compliance, and to assess administrative costs. In order to make a finding upholding the code enforcement officer's decision, I must find there is substantial, competent evidence that the named violator was responsible for a violation of the relevant section of the code as charged. If I affirm the decision of the code inspector, my order will specify the amount of civil penalty, the administrative cost of this hearing, which will not be less than $100 if assessed, and the date by which the violation must be corrected to prevent resumption of continuing violation penalties, if any. An aggrieved party, including the town, may appeal a final order of a special master to the Circuit Court of Appeals. Such appeal shall not be a hearing de novo, but shall be limited to appellate review of the record created before the special master. An appeal shall be filed within 30 calendar days of the issuance of the order sought to be overturned. If you are found guilty of a civil violation as charged, you will be assessed an administrative fee of $100. The city representative will present their case first, and the alleged violator will present their case thereafter. I will consider the evidence and render a decision after all arguments are heard. Now, at this time, if you are able to do so, I kindly ask to please stand and raise your right hand. All those who will be testifying, you will be sworn in if you are able to stand. Otherwise, you can sit down, but if you're testifying, you do need to be sworn in. Do you swear and affirm that the testimony that you will provide will be the truth and nothing but the truth?
Yes.
Thank you. We may begin. And do we have any adoptions, additions, or deferrals?
Yes.
Oh, okay.
Did we do roll call?
We did not do roll call.
We did not do roll call.
We can start with our officer who will be testifying, and then we'll make our way around.
Great. Jeffrey Lewis, Code Compliance Officer for the Town of Pembroke Park.
Brian Sherman, Assistant Town Attorney.
Andre McKinney, Special Master.
Aymara Fontalva, Code Compliance Clerk.
Nasli Cardona, VTR Specialist.
I'm going. I know. That's what I came to Kurt's. And then this is 5940 all the way to 69. Most of the advance.
Got it.
Any adoption of the minutes at this time?
Do you have this? No.
I don't see
No,
any
no.
reflecting on the agenda.
Adoptions of minutes, no additional minutes to be adopted at this current time.
Okay. And I believe, Madam Clerk, you indicated that we do have deferrals, additions, and modifications. Will you be reading that in the record or moving that?
Sure.
Okay.
All right, so we have case 8825. It was removed from item 8.2 to confirm fine and added to item 9.9 to abate fine. We have case 8826. It was removed from item 8.3 to confirm fine and added to item 10.3 to extend time. We have case 8885. It was removed from item 8.4 to confirm fine and added to item 10.4 to extend time. All right, case 10159, removed from the agenda, respondent complied before hearing date. Case 10353, removed from agenda, respondent complied before hearing date. Case 10404 was removed from the agenda, respondent complied before hearing date. Case 10545, removed from agenda, respondent complied before hearing date. Case 11019, the details were modified.
Okay. The motion to accept the deferrals, additions, and modifications is so moved. And I will hand it over to Officer Lewis, and he can call the first case. Are there any attorneys signed in? Okay, so we'll go in order of the sign-in sheet.
Perfect. Great. The first case is case number 10812. 10812 is for the site address is 3615 Southwest 52nd Avenue, Unit B 103. The owner is Anzac Investments, LLC. And this is in regards to a notice of violation, which was written in March 27, 2025, for work that was completed without a permit. The affidavit of service was completed as of 6/10/2025. Formal hearing was posted as of 6/18/2025. I'll get down to the pictures here. Here we are. So this was in regards to a work that was done without a permit. They have filed 4 permits in order to complete the project. However, it is the given time. Spoke with the contractor as of 7/11/2025, and they are seeing that everything will be completed within the next 60 days.
Okay. Okay, thank you. And we're showing, are there any, okay, anything else?
No, we
Okay.
have the property manager here to speak upon the case.
Okay, very good. Can you please state your name for the record?
Yeah,
And
my name is Alex Penaranda.
okay, and you're here on behalf of the owner.
Yes, I'm the
Okay.
property manager. Just Mr. Lewis explained, we have a contractor working on pulling the permits for his unit.
My apologies. Can you speak into the mic?
I-
Okay, can you hear me now? Okay.
Yes.
All right. So as Mr. Lewis said, our contractor is working in pulling the permits from the city. He has some, I believe, some revisions, so he's working hard trying to get those approve as soon as possible so we can comply.
And what's the town's recommendation as far as the amount of time for achieving compliance? And if not, the per diem fine?
The recommendation time is 60 days. If it's not complied within 60 days, it would be a $250 per diem.
And the permit application is to correct exactly what?
The interior build out of the apartment and the permits that were filed is to correct those violations.
Okay. Is 60 days going to be enough time based on?
So,
okay.
as long as we get the permits approved, we are able to complete the job.
Okay. Make sure you stay in contact with the city. If there's nothing else from either side, I'll go ahead and give oral pronouncement. Based on the evidence and testimony presented, there is substantial and competent evidence to support the town's position. The respondent is ordered to come into compliance within 60 days. Failure to come into compliance will result in a daily fine of $250 per day that will continue to accrue until the violation is corrected. The respondent is also assessed $100 administrative cost for today's hearing. If you step over to the side, you'll be able to get a copy of the order.
Okay, perfect. Thank you so much.
You're welcome. Good luck to you.
Ms. McKinney, if I may,
Yes.
for the next cases.
Yes.
So the next cases are 9.1 through 9.8 on your docket for the hearing to abate fine. These are all dealing with 2400 Southwest 30th LLC at 2400 Southwest 30th Ave. There are various violations in various bays that this was included. So essentially, it's the three properties at that location.
Okay.
So it's case 5049, case 5533, case 5622, 5637, 5638, 5701, 5702 at those three bays, which are A, B, and C at that location for various violations. This is a unique situation where, sir, can you please state your name for the record?
Yeah, my name is Yaniv Dresner.
And, I'm sorry.
And you are?
I'm owner / partner.
Okay. Okay. Just to have it on the record.
Yes. So it's my understanding after speaking with Mr. Lewis that Mr. Dresner came in, bought the properties with the code liens on it from a prior owner. All the violations were incurred and the fines accrued by the prior owner. He then bought the property with the liens and basically renovated all three different bays.
Okay.
Now, they're here to abate the fine on these cases, and it's a large sum as to all of them altogether. I'll defer to the remainder of the presentation to Mr. Lewis.
I do have one question. Is 9.8, and you may have said it, case 6297, is that also included within?
Yes, it is. I did say 9.1 through 9.8. I did not
Okay.
read
Okay.
6297. So 6297 is included in this. Yes.
Okay, very good. Good morning again.
Good morning.
Sorry, yes, that is correct. Jeffrey Lewis, Chief Code Compliance Officer for the town of Pembroke Park, in regards to these 8 cases for 2400 Southwest 30th Avenue, LLC. As the attorney mentioned out, the total sum of all the cases together comes out to $1,735,339. This is to abate the fine. The recommendation at first was for 95% reduction, which would bring it down to $89,274. Now, we do understand that this is an extreme circumstance. He did take over the property when this started to accumulate as of
18.
April 14, 2020 was from the first case, and it went through all the way through to 2025. Mr. Drenzer took over the property in 2025 and worked vigorously to have everything in compliance, in which he did complete that within a 6-month time frame compared to a 5-year time frame of when this first started. The other recommendation, and I will defer to the owner to take a look at, but at 99% of a reduction would be $17,353.39.
If I may, Ms. McKinney,
Please.
asked respondent before his presentation a few quick questions. And so you'll have the opportunity to add anything you want to the record, but roughly, and I know you've been in constant contact with staff, what is the ballpark amount of money have you spent as far as rehabbing the properties?
Yeah, so I got a little sheet over here.
Right.
And it's rough numbers, but they're accurate. They're like right there, not really for the dollar, but we put a new roof, brand new roof. It's a 15,000 square feet building, so and we went with a better roof, so we have about $214,000 just for the roof. That building never passed the 40 years recertification. We did that also. We have about $7,000 in spendings. We put a fire panel. We repair all the sprinkler system, so that just the fire and the sprinklers were about $11,000. And then to close all the violations that were still open, everything that was done without a permit, we took a contractor, and we spent about $65,000 to bring the building back into compliance. And then we had about $48,000 in engineering fees and architectural fees, bring us to about $345,000 that we spent on top of the purchase of the building. We're getting ready to go into phase 2 of our project in that building, which is we're going to operate out of that building. We are a small company, a clothing company.
That was my next question.
Building, we purchased it not in order to turn a profit, it's just to operate. That will be our first building that we actually purchase. Until now, we're in business since 2018, and that's our first building that we actually purchasing. Before that, we were renting in North Miami. So phase 2 will be installing offices, building offices. Right now, it's just an open shell. Obviously, the alarm, cameras, storage racks. There's another garage door that need to be installed in phase 2. And then we pay attention when we purchase the building. We put a new roof, but the canopy up front, it's just like it's really more for the look. It's architectural shingles,
Right.
and even that it's fairly new, whoever did the job over there, it's terrible. I mean, we have shingles falling even without rain; they just fall. So we're already getting quotes to replace the front canopy, $25,000 to $30,000 on that as well. So ahead of us, it's another $109,000
For phase 2?
for phase 2 that we're gonna have to spend in that building. With that said, the $342,000 that were spent already, $140,000 was what the company could afford as far as out of the company pocket. The rest is really loans. So, and going into the phase 2, that will have to be financed as well. So we're coming here today and you know, asking for some help. You know.
Can I get the amount of time that the new owner actually brought all these violations? The record also reflects that at least 3 of these violations, or 4 rather, were repeat offenses by the prior owner. Is that correct?
Yes, that is correct.
Okay.
The fines and the amounts started to accrue prior to the new owner. So this was all done by the prior owner with all the 3 different bays, Bay A, Bay B, and Bay C, of interior work done without a permit, the fence, fire alarm system, fire sprinkler system, demolition of bathrooms without permits, opening of the bays without a permit, so on and so forth. And that was all taken care of. The last case, which is 6297, which came into compliance as of March 26, 2025, to make sure everything has been completed and closed.
When did you acquire ownership of the property?
November. If I
Of
remember.
2024?
Yeah.
Okay.
November 2024, end of November, and then it took us a couple weeks to kind of put it together with the architect, and then we ran into the New Year's and Christmas. So really, we really started working in January, and
I think this case might be a record for me in terms of the number of violations and work without a permit and just dealing with the permitting process can be a very lengthy process, starting with getting the professionals to be able to submit the permit application. So definitely commend your extreme due diligence in bringing the property into compliance. The city is, or the town is recommending, or I guess offering or suggesting a 95% or 99% reduction, which is not the norm, but this isn't a normal abatement case, and I do recognize that. So can I get more clarity from the town in either scenario, what the ultimate recommendation is?
Right. As a extreme circumstance, typically we can go up to 95%
Okay.
of a recommendation, but since, again, this was completed in a quick time frame with fees amounting up for over 5 years, we're recommending 99% reduction, which would bring it down to 17,353.39 for all 8 cases.
What's your position with regards to the city's position? I will share, based on the testimony and the evidence and the number of cases and the compliance achieved in a relatively quick, extremely quick, I have to say, based on the evidence, bringing all of these cases into compliance. I'm accepting the city's recommendation at 99%. Hearing no objection from the city or the council, and that amount would be $17,353.39. Do you need time to pay that amount?
I mean, we'll pay it. I mean,
If you need time, now's the time to ask.
when we say time, I mean, we'll pay it within a week.
No, okay.
I mean, given the amount and the issues involved, and all it is the reason why, may I, Ms. McKinney, is that if it's not paid within the amount of time set today, then it goes back to the full amount. So, understanding the issues, we'd agree to 90 days to pay.
Okay.
You can pay any time within that time frame.
Did you understand that?
So within
So
90
when someone applies for abatement or to reduce the liens, you have to pay the reduced amount by the, and so if you need more time, which the city, based on the unique and extreme circumstances of this case, they're giving you 90 days to pay $17,353.39. If you don't pay that amount within the 90 days, the original amount of the fines will resume. Okay? Let me give my formal oral pronouncement for the record. Based on the testimony and evidence presented in this extreme case, and I'm just going to read it by the, this is a global settlement for case number 5049, 5533, 5622, 5637, 5638, 5701, 5702, 97, property address located at 2400 Southwest 30, and this is Bay A, B, and C. There is substantial and competent evidence to approve the request for abatement for the foregoing cases. The fines are mitigated to $17,353.39. The administrative costs are included in this? Some?
Yes.
Officer Lewis? Okay. You must pay this mitigated or abated amount within 90 days, or the original fine amount for each of the cases I've read into the record will resume. Okay? Good luck to you.
I just want to say thank you for Jeffrey Nasli, Amara, and I know Mimi is not here, but I mean, this crew help us a lot, you know, and making it happen, you know. So I appreciate that. All right.
Good luck to you.
If you give me a moment, I can get you the copies, or okay.
Are you good for us to continue?
Yeah, since he has like 8 orders.
Okay.
I'll get the papers ready and then, you know.
Okay. Okay, we can call the next case.
We've called the next case. Okay, great. The next case is 9789.
It's 10.5 on the docket.
Okay.
It's Pembroke Park Warehouses Holdings, located at Southwest 21st Street, number 675. It's a hearing to extend time.
Perfect. Jeffrey Lewis, Code Compliance Officer for the Town of Pembroke Park for case number 9789, located at 3121 Southwest 21st Street, Bay 675, for Pembroke Park Warehouse Holding. This is for work that was done without a permit. Notice of violation was started in June 21st, 2024. Affidavit of service was posted. July 2nd, 2025. And this is to extend the time frame for the violation of work without a permit. We received the extension of time, and we are recommending 60 days for an extension.
Okay. Good morning. If you could state your name for the record and who you are.
Good morning. I'm Nancy Romero, the Senior General Manager for Pembroke Business Park.
Okay. Your face looks familiar.
I've been here
Okay.
many times.
And so if I could, so we're extending the original final
Final
order
order.
date for compliance.
Correct.
Is there anything else you'd like to add? This is your request.
This is perfect. We're almost at the end of getting the permit.
Okay.
I'm just waiting for one more report, the asbestos report, and as soon as that's done, we'll submit it and hopefully get the permit.
Okay, very good.
Correct. The
and-
last review for that permit was done on July 2nd, 2025, so it is in progress.
Okay, great. And the fine amount that was for this case previously was $250.
350.
Repeat offense.
Correct. So from the last final order, which was on March 19, 2025, and it was given 90 days for and a per diem of 350.
Okay, very good. You understand that, and I just wanted to be clear because it is a repeat offense. Based on the testimony and evidence presented, there is substantial and competent evidence to approve the request for extension of time. The respondent is ordered to come into compliance within 60 days. Failure to correct the violation and come into compliance will result in the fines accruing daily at $350 per day until the property is in compliance. Administrative costs in the amount of $100 are assessed. And for the record, this is a repeat offense. Case number 9789 is a repeat offense. Good luck to you. You'll get a copy of the order.
Do you want me to email it to you, Nancy? Okay, thanks. Thank you.
We can call the next case.
Perfect.
Everything's extra loud today.
The next case would be case number 10519. That is on
7.4.
7.4.
Thank you.
7.4 under section 7.
I did not.
To Daquan Stevens, 3944 Southwest 40th Ave, Pembroke Park. It's a formal hearing for violation section 5-105, repairs and installations, 5-17, a permit application, first offense.
Correct.
It's the first violation.
Code Enforcement Officer Jeffrey Lewis for case number 10519, located at 3944 Southwest 48th Avenue in Pembroke Park. This is for the ownership of Daquan Stevens. Notice of violation was first written in January 9th of 2025. This is in regards to a wooden fence that was installed without a permit. They need to obtain a permit for after the fact issue. Affidavit of service was done on July 3rd, 2025 to the location, and verification photos was taken as well. The original notice of violation was given 30 days, and it is still not in compliance as of today.
And what's the town's recommendation as far as days of the number of days to come into compliance and any per diem fine for failure to meet the deadline?
7.4. The recommended per diem is $100 per day, given 60 days to complete the process. If it's not completed within 60 days, it would be $100 per diem.
Good morning. How are you?
I'm good at yourself.
Good. Can you please state your name for the record and who you are in relation to the subject property?
Oh, I'm Daquan Stevens. I'm the owner of the property.
Okay, so based on the testimony, it sounds like this is a after-fact permit that would need to be applied, inspected, and closed out for a wooden fence that was,
Installed without a permit.
thank you, installed without a permit. And you would have to get that done within 60 days or face a $100 per day fine.
Okay, that's fine.
Okay, I'll give oral pronouncement based on the,
Quick thing.
Yes.
I know someone went out to the property on July 7th and did an inspections. I just want to know the feedback from it.
Yes, I went out on July 7th. I met with the tenant. We were able to take a look at it, and it is a so that would need to be properly done with the contractor to show that the footing was
Okay. My contractor is currently working on it.
Correct.
He sent in a couple of documents. I'm not sure when, but it was recently, just to get everything squared away. So,
okay.
yeah, I think the 60 days would be good. The extension.
if you need more time, now's the time to ask.
Okay,
better,
well,
better erring on the
Better
side.
to have more time than to have 60 days. So if I could get more time, that'd be great also.
Okay. I have a question. Has your contractor or you, have they submitted for the permit application?
Yes, and so the application was denied because he had to do the drawings over.
Okay.
He had the wrong application for some strange reason, and I'm not sure why he didn't go back over it, but that's, yeah, he just had to fix it. So he's fixing it now, and then he'll resubmit it, and then we could go from there. Because the whole purpose of the fence was the HOA. My fence was currently like messed up, and my previous tenant was complaining about it. So I mentioned it to the property manager, and I asked him if I needed permits or anything of that sort. They never mentioned anything about that. So that's why I went ahead and did it. But yeah, now I know.
Okay. So based on that testimony, I'll go ahead and issue 90 days.
Okay.
Let me give oral pronouncement. If there's nothing else by either side, based on the testimony and evidence presented, I do find that there is substantial and competent evidence to support the town's position that violation exists on the subject property. You are ordered, the respondent is ordered to come into compliance within 90 days. Failure to come into compliance within 90 days will result in a daily fine of $100 per day that will continue to accrue until the property is in compliance. And you are assessed $100 administrative cost for today's hearing.
Okay. What do I pay?
You could come into the office. That would be set up in our system by tomorrow.
Oh, okay.
By tomorrow? You
Yes.
know, because I stay out
For
of
this
town.
case as well?
So can I pay like
perfect.
online or
Thank you.
something like that?
No, unfortunately, we cannot accept online payments for the code enforcement.
Get it the day before I leave and have someone bring it.
Bring it or mail it in. Yes.
Okay.
Make sure you put your case number and your property address on any check if you're not gonna drop it off personally.
Okay, I could drop it off today, even though it's not gonna be. Yeah. I gotta pay now because I'm about to leave. So. Okay. I'm pretty sure they know me. I call every day.
And I've never,
They answer the phone and they say my name.
I've never
this
known
Daquan?
the government or the city to refuse money.
We done?
Yes, good luck to you. You too.
8812.
Okay. Would you like to call the next case?
Yes.
Be section 8.1 here to confirm fine 8812 Edwin Wendorf, 139 Lone Pine Lane, Pembroke Park, Florida. Here to confirm fine.
Go ahead and present.
8812. Great. This is for, Jeffrey Lewis, Code Compliance Officer for the Town of Pembroke Park for case number 8812. This is for address 139 Lone Pine Lane for Edwin Windrow. This is in regards to a notice of violation that was written back in 1st, 2023. This is installation of addition without a permit, installation of a shed without a permit, property has blight damages, outdoor storage prohibited, and miscellaneous items that needed to be cleaned up around the property. The affidavit of service, which was posted onto the property as of July 3rd, 2025. I apologize, July 2nd, 2025. This is a hearing to confirm the fine. At this current time, it is not in compliance, and the fine amount is $9,400.
Good morning. If you could kindly state your name for the record and who you are in relation to the subject property.
Yes, good morning. My name is Graciela Gonzalez, and he's my husband, Edwin Wendor. We are the owners of the property.
Okay. So, Mr. and Mrs. Gonzalez, today's hearing is to confirm the fine. That just means the violations are still in existence. It hasn't come into compliance, and the fine started running. And as of today, or to date, it's out of compliance. And the amount that the town is recommending for confirming is $9,400. But the fine.
Okay, yeah, I just want to add to the record that the fine will continue to accrue until compliance is achieved.
Correct.
And that's what I was going to state, that the fines are still continuing to add up until it comes into compliance.
Okay, I think we thought it was everything done because sir, we do everything what you was saying. We have to fix, we have to clean, and we got a permit already for everything. I don't understand why.
The only open item that is left is your permit for the addition. That is still under plan review. That was just recently brought back in to comply with. And once the permit is issued and the job is complete, then you will be in full compliance. But everything else, which means that the shed, the outdoor storage that needed to be cleaned up, the blight, all of that has been in compliance. The last open item is your permit for the addition.
The addition, is this what, an illegal conversion? The addition?
The addition, correct.
Okay.
No, el permiso de toda la ampliación. ¿Dónde tienes que dar ese permiso? I'm sorry. I don't know that much about that because I was in my country for a long time, and he says he was talking to you all the time to
Yes.
to do that, and he come here to get a permit. I don't understand that much.
Correct. The last item that you just brought back in, which was the survey and elevation certificate for everything to be finalized, that was just processed on Monday. Once that inspection is completed, then you'll be in full compliance. But until that has been completed, you are still running a per diem fine of $100 per day.
Okay, how long time are you gonna take to get a permit? I don't know. I'm sorry, maybe I don't understand that much.
Give me 2 seconds.
No, es que no te han dado todavía el permiso.
And Officer Lewis, just to compliance should have been achieved. Well, let me let you look up that information.
Which was done in plan review, alterations.
Sí, fíjate que está todo presentado, pero todavía no te han dado el permiso. Y hasta que te den el permiso está
Right.
esa multa.
Well, Officer Lewis, are you ready?
Yes.
Okay.
For the addition, the last plan review that was done was back in May 5th of 2025, which had the comments showing that they needed a certificate of elevation and the survey for that property, which was just brought in. It's been processed. So that's going to probably take about another week and a half to process and do the plan review. Once that has been approved, that's the last thing that you're missing, so we can issue the permit. The question is, how long is it going to take to call in the inspections and have everything completed? If that's done and completed within a reasonable time frame, then we will be out there for inspection and close out the permit. So this can be within 2 weeks, or this can be within 2 months. It's up to how long it's going to take for your inspections to be completed.
How we can just get to you guys to do the inspection? I don't know.
Currently,
to
you're
do
in
that?
currently you're in plan review. So we're still waiting for the structural inspector to make sure that the plans that you submitted has been approved and is accordance to the Florida Building Code. Until that's been taken care of, we can't issue you a permit so you can do your inspections. So the process is bringing in the information correctly, having it reviewed, then us issuing a permit, and then you doing the inspections.
Hay que hacer la inspección.
Ms. McKinney, at this time, the city is requesting to confirm the fine.
Yes. Mr. and Mrs. Gonzalez, so, and I think Ms. Gonzalez, your testimony is that you were out of the country and Mr. Gonzalez.
No, he's Wendorf, I'm Gonzalez. But
Oh,
you
I'm
know,
sorry.
We was doing this together. We know we did this. He did the addition without a permit.
Right.
But I think we was doing what we always came to talk with him before I went to my country. I came with him to try to help because the English is
Right. No.
important. As you can see, I can just
No, I no.
yeah. Maybe I don't understand what.
So and so let me just kind of bring it all in. So your particular case had various violation items on them.
Yes.
You corrected everything
Yes.
except for the one permit for the addition. And that may have been something that, I don't know, it may have been something that maybe slipped. In either case, the testimony reflects that what was needed, Mr. Wendorf, he provided that to the town, but that was back in May. Now, permitting process, just as the word states, it is a process, right? Because your permit and plans and applications is not the only one, which is why when you get a courtesy notice for a violation, you got to get on top of it like right away. So what has happened is, even though those other items for your case have been complied with and corrected, you have to be in compliance with each and every item detail before the entire case is closed. And that's why the daily fine is continuing to accrue. However, the town of Pembroke Park does offer a mitigation or abatement where you can ask for the fines to be reduced, but that's after compliance. That means once you get the permit and you call in inspections and the inspector closes it out. So for today, it's just to confirm the fines. You can probably make an appointment to speak with the city and they can answer more of the technical timeline questions. Okay?
Okay.
Okay. No, you're welcome. If nothing else from either side, I'll go ahead and give oral pronouncement. Based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position to confirm the fines. To date, the property remains out of compliance. The fines are hereby confirmed. To date, the fine amount, but this fine is still running, is confirmed at $9,400 with a daily fine of $100 still accruing. And there are administrative costs of $100 for today's hearing. You will get a copy of the order. Please get with the city, to keep track of where the plan review is.
Yeah, now I'm here. I'm gonna be involving of this.
Okay.
Thank you so much.
You're welcome. Good luck to you both. And once you're in compliance, you can apply for abatement.
Digital copy.
The email what?
The certificate of elevation, we need the digital copy. Make sure you send that in. Okay? Okay, perfect.
Okay,
All
okay.
right, you're welcome.
Okay. Next case is 11019.
Yes. 11019 is on.
And is this? Yeah, this is formal.
11019 is 7.9 on the agenda. And then that would also be for 10736 as well.
Okay. Do you want to go? Well, I'll let.
Ready?
Yes.
Okay.
Brian, are you? No, whichever order, whether sequentially or the order of the sign-in sheet.
Understood.
Okay. Are these two different?
No, the sign-in for 6 and 7 are both on 7.9,
Right.
which would be.
No, the signatures are
Yeah, looks like there's 3 people signed in for case 11019.
right.
7.9 under docket NHP SH Florida LLC, 5100 West Hallandale Beach Boulevard, Pembroke Park, Florida. It's a formal hearing for repairs and installations and permanent application. This is the city's considered this a first offense.
Correct. Jeffrey Lewis, Code Compliance Officer for the town of Pembroke Park, for case number 11019. This is located, the site address is 5100 West Hallandale Beach Boulevard for NHP SH Florida LLC. This is in regards to a notice of violation for installed drywall without permits, and that would need to be corrected after the fact permit. The notice of violation was written back in May 19th of 2025, and currently it has not been in compliance. This is for first hearing.
Is there a recommendation? Is there a recommendation?
Yes.
Okay.
7.9. The inspection was January 1st. Yes, so the recommendation would be to be in compliance within 60 days. If not in compliance within 60 days, a per diem amount of 250 would accrue until compliance is reached.
Good morning.
Good morning.
I'm not sure who will be speaking, but if you could state your name for the record and who you are in relation to the subject property.
Okay, my name is Susan Hernandez, and I'm the executive director over at the Peninsula. was this, what we got the violation for.
Okay, and this is an LLC, and you have authority to speak on behalf of the managing members?
Yes,
Okay,
and this is also Norman, he's the maintenance director, and he's here with me.
okay. Good morning. So you've heard the testimony. Excuse me one moment. Madam Clerk? I'm sorry. Yes. Sorry about that. You've heard the town's testimony and the recommendation to bring this violation into compliance. What's your position?
I'm the executive director, and right now, we're waiting on the contractor, Patrick, to file for the permit.
Okay, so you have hired a contractor?
We have a contractor, yes.
Okay. And so it's just the process of submitting. The permit application is for what exactly?
The permit
For the record.
application is going to be for the walls and also the changes in the fire sprinklers in the theater room.
They already changed the sprinklers.
Right, but they never pulled a permit
Yeah, we're waiting for the plan, yes.
for the change of the fire sprinklers.
Correct.
Right.
That's what
Okay.
we're working on.
Ms. Hernandez, so the town is offering 60 days. This is a first offense, and it's the first time up before special magistrates. And so is 60 days going to be enough?
Yes.
Okay. If there's nothing else on either side, this is for case number 10736. Based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position that a violation exists on the subject property. The respondent is ordered to come into compliance within 60 days or face a daily fine of $250 per day, which will continue to accrue until such time as the property is or the violation, is in compliance. The respondent is also assessed $100 administrative cost for today's hearing. You have another case.
Yes, we do. That's what,
That would be for case number 10765.
No, 736.
Oh, my apologies.
Okay, so my oral pronouncement was for 736, so that's in reversed order. The oral pronouncement previously given is for case number 11019.
Okay, wait, I need clarification. So case 11019 is 60 days with the 250 daily fine?
Correct.
Okay, all right. 250? Yes.
250.
And then 10736. We haven't
We're
given-
just doing now.
No, 10736 7.6 on the docket. 5100 West Hallandale Beach Boulevard. NHP SH South Florida LLC is the owner. A former
Code compliance officer for the town of Pembroke Park. For case number 10736, the site address is 5100 West Hollandale Beach Boulevard for NHPSH Florida LLC. This is in regards to a notice of violation of formal hearing for work that was done without a permit for installation of a generator at the location. The notice of violation was original as of March 5th, 2025. Affidavit of service was given, and that was posted as of July 3rd, 2025. At this current time, there are no permits for the installation of the generator, so it is still an open violation. The town's recommendation is to give 60 days to comply. If not, it would be a $250 per diem.
My name is Dana Welch. Excuse me.
Good morning, Mr. Welch.
Good morning.
What's your position with
I'm the owner of Megawattage.
okay, and what's your position with regards to the violations? Looks like you need a permit for a generator.
Right. We provided a rental generator, a temporary generator. We pulled a permit back on 4/22. I've got a permit number.
Sure. What is that?
Permit number 392-07152.
Okay, 392-07152. Okay, let's.
Yes, that is the application number It's been denied since 5/7/2025.
Okay. And I believe it was denied by Inspector Kyle White.
Which is our fire, correct?
Okay. And the reason it was denied, it was, we're trying to close it out. We're trying to remove the generator, but apparently the property does not have a backup generator. So we're unable to close it.
Correct. So you would need to speak with the fire inspector and
Yeah, I've been in contact with him and he's
Okay.
gone to the property and hasn't confirmed that there's a backup. So he won't let us remove the generator
correct.
until that.
Is there a secondary generator currently installed and up and running, or?
You'd have to ask the owners.
Well, I can answer that. Right now, we have the temporary generator because of our previous generators not operating properly. So we're using the rental.
Until
Until we can get
the backup is up and running?
We have two, neither one of them, right, Norman, is functioning.
We're actually waiting on an
Electrical engineer to do an analysis to see if they can connect the previous generator, then we can have the other one.
Understood, right, because of the type of facility that you have, you
have to have
are
temporary.
required in order to
Correct.
is 60 days enough?
For lack of a better phrase, technical issues that you are experiencing? Is 60 days going to be enough time?
Maybe 90 would be better.
Okay.
Now, I'm sorry, is that directed to me or? I'm,
The permit, I mean, we still need the permit. He still needs the permit because we're still renting the generator for mega wattage.
Correct. Unfortunately, it's been denied because you cannot remove the temporary generator because the
Without-
backup generator cannot be issued. Therefore, it would need additional time so that way you can have the permit for the temporary and then the removal of that because your backup generator is now up and running. The thing of it is, the temporary generator was installed without a permit, and that's where the violation comes into place. So in order to cure the violation, you need a permit, but unfortunately, you can't release that permit because you don't have,
Something to replace the,
if your ultimate goal is to remove that temporary generator.
based on other professionals or other individuals you're working with. So just based on my experience, I don't know anything more than what I'm hearing about your case. 60 days could be achievable, but there is a permit process that every town or city undergoes. And so based on what you, intimate knowledge about the property that you guys hold, is 60 days going to be enough time? Okay, okay.
Well, Madam Magistrate, the only thing is obviously if there's a storm or other event, that would be just the town's underlying concern for the safety of the residents involved.
Because we're in hurricane season.
We know that. That's why we have the temporary, and I don't want the temporary one removed until.
Well, by code, you can't remove it because you don't have anything else. So don't do that because that would be another violation.
No, I know. I have, 106 residents there.
This is what I am inclined to issue an oral pronouncement. We are in hurricane season. This violation is one that I would consider that is health, safety, and welfare because of the particular subject property. I'm inclined to go with the town's recommendation with you guys keeping in contact with the officer, and if you need an extension, because this is something that you do have to bring into compliance. And so having 60 days and the clock ticking, I think ought to allow you to apply the necessary pressure with whoever you're dealing with to get this done. And if you need more time, you can contact the town. That's what.
I just want to make it clear, I'm just, megawattage is just providing the generator.
Okay.
We're not, have nothing to do with correcting their actions there. We're just providing a rental.
Understood, but the way that it was connected and how it's hooked up, that needs to be verified by our fire inspector and our chief electrical. Unfortunately,
Completed, it was denied. They were out there.
correct. So therefore, you still need to get in touch with the fire inspector and double check with the comments to make sure that you are in compliance with everything that's
Right,
there.
which
In order for
we
us
have.
to issue the permit to even allow that to stay in there.
Yeah.
Now, your ultimate goal is to remove it, but apparently you won't be removing it anytime soon. So this will go ahead and cure that violation of having your fire inspection and your electrical inspection, making sure that everything is in compliance with the temporary one for now. Once that's completed, you'll be in compliance.
And that's probably going to be the path to achieving at least compliance. Now, once you obtain a permanent solution, they will need to apply for another permit for that as well.
The
'Cause
backup
right now it's
generator
a
is
rent-
already there, it's just not working. So
Oh,
they would
okay.
need to maintain it to get it up and running.
Okay. Just wanted to.
So that's where that time frame plays into place, because you don't know how long it's going to take you to get it up and running for them to remove the temporary one.
And
That's where you
meanwhile,
are in your dilemma.
the violation still exists. So I think you guys understand. I think that answers your question. The record reflects that the permit application was denied on May 7th. We're now here July 16th. And so time has already, escaped, if you will. If there's nothing else by either side, I will give oral pronouncement. Based on the evidence and testimony presented, there is substantial and competent evidence to support the town's position that a violation exists on the subject property. The respondent is ordered to come into compliance within 60 days or face a daily fine of $250 per day, which shall continue to accrue until compliance is achieved. And respondent is also assessed $100 administrative costs. Please stay in contact with the town and Officer Lewis so that fines don't start running and everything. Good luck to you.
Okay, all right, thank you.
You're welcome.
Can you give me a moment? I'll get you a copy of the order. You already signed the other one, that's fine.
We're at 10366.
Yes.
Yes, the next case is 10366. It's number 10.7 on your docket. It's DCT/CE LLC, 2400 Commerce Center Way, Suite 300, Pembroke Park, Florida, hearing to extend time.
Perfect. 10366. There we are. All right.
Yes.
Code Compliance Officer Jeffrey Lewis for the town of Pembroke Park for case number 10366 for 2400 Commerce Center Way, number 300 is the site address for DCT CE LLC, also known as Prologis. This is in regards to installation of a rack system without permits. The original notice of violation was done November 14th of 2024. The final order was given in April 16th of 2025. And the affidavit of service was posted onto the property as of July 2nd, 2025. This is to extend the time frame to allow them to have additional time from the final order. The town is recommending 60 days to be able to complete the permit process for the installation of racks.
Or the daily fine of $250.
Final order.
Because, all matters of the prior order would stay in.
Okay.
The actual per diem is $350.
Okay. Hello, state your name for the record. Good morning, and who you are in relation to the subject property.
How are you?
Good.
My name is Gustavo Volado. I'm the architect of the tenant, in fact.
But are you here with authority to speak on behalf of the owner?
Yes, the
Oh,
manager
okay.
is here,
Okay.
but I'm in charge of the works.
Manager, can you state your name for the record?
My name is Gerardo Spina.
Okay. And you represent the owner?
Yes.
Okay. And the architect is authorized to speak on this violation? Okay, thank you.
I'm so sorry. Gerardo Spina?
Yes.
Can you spell your last name, please?
Spina.
Thank you.
We submit the plans, approve the permit, we make the inspection. We approve the inspection. It's only one final
Item remaining?
action to close the project.
Okay, so the town is offering 60 days extension?
Perfect.
Okay. Otherwise, the fine of $350 per day, the same fine, will continue to.
We're going to modify that to 250.
We are? Okay.
Yes.
Okay.
This is, I believe the underlying order is for a first offense. So with the extension, we're going to modify it to 250.
Okay. Okay. Anything else by either side? I'll give oral pronouncement and you'll get a copy of the order. Based on the testimony evidence presented, there is substantial and competent evidence to approve the request for extension of time. The respondent is ordered to come into compliance within 60 days. Failure to come into compliance and correct the violation will result in a daily fine of $250 per day accruing until the property is in compliance, and there's $100 administrative cost assessed.
Okay.
Okay, good luck to you.
Thank you.
You're welcome.
Well, this will do both. Right. All right. So we have the next are, it looks like that we have signed on 2 cases. It's actually 3, it appears. So part of the modifications to the agenda is 8.2, 8.3, and 8.4 were all moved, but they're still listed on the agenda. So you may want to cross those off because they're on as 8.2, 8.3, 8.4, and 9.9, 10.3, and 10.4. So we're going to address it as 9.9, 10.3, 10.4, and its cases 8825, 885, and 8826. Let me read them. It's Warehouse 1800 LLC at 2401 John P. Lyons Lane, B17 to B18. This is a hearing.
Well, 2 to extend and 1
Right,
to abate.
exactly, and that's why they were all moved. So 1 to abate, 2 to extend, and then 10.3, 8826. Same owner from B19 to B22 for the bays, hearing to extend time, and as well as case 8885 for bays for bay E15 for hearing to extend time.
Officer Lewis, whenever you're ready.
So we're starting with 8825,
We'll start with 8825, 9.9.
9.9. Okay. Co-compliance officer Jeffrey Lewis for case number 882. Warehouse 1800. This is in regards to a notice of violation for operating without a business tax receipt, renovating or combining the 2 bays, and installation of an auto lift station, all within. In this case for 8825, appliance was achieved as of April 22nd, 2025. This is a hearing to abate the fine. The amount that accrued is In total is 15,950. Town's recommendation is 85% reduction of the amount, which would bring it down to $2,562.50.
Good morning. Can you state your name for the record and who you are in relation to the subject property?
It's Teal Benson. I'm I rent the property.
You're the tenant? Are you here with authority to speak? Okay, and you can represent on behalf of the owner that he can speak on this abatement?
Yes.
And state your name for the record so Madam Clerk can get that?
Fernando Rodriguez.
Okay. Okay, so congratulations, the violations are in compliance. The town has offered an 85% reduction, which brings it down to $2,562.50. This includes the administrative cost.
What's not adding up
That
to?
abatement is written, we have additional extensions that were sent through text message.
Ma'am, please state your name for the record.
My name is Amanda Rainbow, I'm the Director of Operations for the company. I know they met with
have
you
to come
guys.
up to
Sorry,
the
I know they
mic.
met with you guys. There were additional documents that were sent from inspectors through text message that gave additional extensions. So the abatement, the fines would be based on a time period that isn't the correct time period before we could deal with abatement or reduction.
I'll let the town and or town attorney respond, and they can add clarity to. But I understand what you're stating.
Just to confirm, the evidence that you're trying to submit is for 8825, correct? Case 88. Okay.
And you have something in your hand that you're showing.
That needs to be.
I don't know.
That would need to be
Well,
submitted.
if you submit it to the record, then the town, Madam Magistrate, will get to review it. We'll get to review it. You're able to submit any documents that you would like. It just becomes part of the record. Do you want to submit it at this time? Sure. Please hand it to Mr. Lewis and myself. And I'll hand it to Madam Magistrate, and we'll mark it as Defense Exhibit
Or
1.
respondent.
Respondent Exhibit 1.
90 days extension. This over here is January 18 when.
Yeah, but there's no date.
Here, let me take a look at it.
Oh, that's January. Okay.
Yes.
Whose number is it, though? I mean,
Now, this was sent to,
Officer Lewis, when I get a chance to take a look. But what we can.
So what I'm looking at is, it seems to be a printout, just a printout of a phone regarding the process. It seems to say there's a text. There's some text written over it as well from, I don't know. Listen, no, it's a picture of an email. One's a picture of an email from Miss Cardona, and it says, to me, comma, Jeffrey. It says, good morning, Tio. Business act received been approved by zoning. The next step is to schedule fire, structural, and electrical inspections, and inspection fees are due. Total amount $250. The date. It appears. Again, this is a picture of an email that's on something else. It appears to say, I believe that's what, January 18th,
Yeah, that's correct.
2024.
And after that, we comply with the.
Well,
these actions.
Well, and so this is just saying when the next steps are for this particular one.
correct.
Passing that to Madam Magistrate now. The second one in the same kind of format are just pictures printed. It says handwritten November 20th. And then it says from 303, we have pictures of an order. It says 90-day extension, just left mechanical for Theo at building department B17-18. But there's no to, there's no from, there's no number. It does say November 25th, but it just says Armando SBG, and there's no other indication of what there is. Are you saying that there was an order for an extension? Because that would be in the record. So what is the compliance date you're saying?
They approved the extension.
Who's they?
I'm assuming he means the town. So there was an amended final order back
Correct. That's what I'm getting at.
2024.
Right. So the 90-day extension you're talking about is the amended final order, correct? And that was done at this particular hearing, correct? Okay. And so the compliance date, you're just seeing this 90 days, but are you saying the compliance date used by Mr. Lewis was incorrect?
When was the last time you got the inspection?
I want to see exactly what we're arguing about. Well, here, Mr. Lewis, what's the compliance date you have on file?
April 22nd, 2025. To go back through this case in the case history, this was originally written August 24th of 2023. It had a final order back in September 18th of 2024, which gave them 60 days in order to comply. They did an extension of time back in November, which gave them additional time frame of 90 days in order to be in compliance, which would have gave them up to February 20th of 2025 to comply. And then the compliance date is actually April 22nd, 2025.
So in order to calculate the fines, you use the April 22nd compliance date, 2025?
From April 22nd, 2025, correct.
So
So the time frame in between was 63 days.
So the extension that the respondents are alleging wasn't included was included.
Was included at the original time frame.
Correct.
This was a $250 per diem fine? An accrual at $250?
Correct. That was at $250 per day.
What was the one?
So we're saying that the fines as presented and as reduced began on April
22nd,
2025.
2025.
Okay, so do you have any contention that that's the wrong date?
Was it completed prior to that time frame?
Well, we requested the inspections, he's the one who.
Yeah,
Correct.
I requested inspection and they told me the inspector was was on vacation.
So, all right. So as far as I think it's clear as far as the record's concerned that the compliance date is no longer at issue. Understanding the rest of it would be, of course, within your discretion.
Ma'am, your name is it Miss Amanda? Okay, so just so we can wrap this on the record, so the record reflects that you have handed two sheets of paper based on your position that the mitigated or abated amount was not accurate because of an extension. The record reflects that there was an amended final order that granted an extension of time. The record also reflects by testimony of Officer Lewis that the calculation for the fine amount, meaning the original fine amount of $15,950, stopped when the property achieved compliance, and based on that figure, the town has recommended abatement to $2,562.50. And you concede that, having heard, okay, very good.
I just flew into town, I didn't realize that you guys had amended the date, so I just want to make sure they got it in.
Okay, very good.
Thank you so much.
You're welcome.
If additional reduction is granted by the special magistrate of up to 95%, it would bring it down to 797.53.
Okay, very good. I'm sorry, I forgot your name, Mr. Tio. The town, this is a warehouse. It's not homestead property, and so the town for these types of cases mitigates to 85%. It is within my discretion, but I'm not going below the town's recommendation. $2,562.50. Let me give oral pronouncement. I do want you to let me know whether more time will be needed to pay the fine amount. Based on the testimony and evidence presented, there is substantial and competent evidence to approve the request for abatement. The fines are mitigated down to $2,562.50. This includes the administrative costs. If you do not pay that amount within 30 days, the original fine amount will resume. Do you need more time?
Yes, I do.
Okay. How much time do you need?
90 days, I guess. 90.
Okay.
That's fine.
I will grant you 120 days. You've got to make payments within that time frame. Don't wait to the 121st day, because if you fail to pay that amount, the original $15,000 will be reinstated. Okay? If or town attorney can give an introduction into the next case.
Sure, this is, again, the same property, bays B19 through B22, 8826, 10.3 on the docket for Warehouse 1800 LLC. This is a hearing to extend time.
Eight eight two six. Case number 8826, Jeffrey Lewis, Code Compliance Officer for the Town of Pembroke Park. The site address is 2401 John P. Lyons Lane, Bay 19 through Bay 22. The proper ownership is Warehouse 1800. In regards to a notice of violation for operating a business tax receipt and a certificate of use without a renovating and combining 4 bays together without a permit, and installation of an auto lift as well. The original notice of violation was August 24th of 2023. Final order was given September 18th of 2024, giving them an additional 60 days in order to comply. We went back into this case and took a look, and they actually complied within the time frame of the final order as of November 19th of 2025.
Okay, so this is closed complied?
Correct. This has been complied.
Okay, well, congratulations. Case number 8826 for property 2401 John P. Lanes, Bay 19 through Bay 22 is closed complied. Okay.
There's no fees for the hearing?
Just the administrative fee that was already assessed. So if whatever's on file between the $100 administrative fee still might be owed.
Correct.
You'll have to check with the town to confirm that's paid.
Which
that would
case?
be
This is 8826.
No, none of the cases paid their admin fines.
right. So there is an admin fine of $100, and that's from the final order back in September.
Okay, so you need to pay that.
Okay. I want to make sure.
Okay, so we're down to case 8885.
And this is for the same location, except Bay E15. Is this the one that? What was the date?
Yeah.
So on this, in review of this particular case, there's a small dispute as to when it came into compliance. However, they're within a week of the compliance date. You're looking at when they contacted the town versus, again, when a compliance was achieved. But given the small amount of time involved, the city at this time is going to request to extend the compliance date about a week to, what's the date? Or even 30 days. Again, we can
Just give 30 days from January 15th.
So we're going to extend the compliance date to February 15th. They did comply within that time frame, and then this would close this case as complied once the order's modified. Again, the administrative fees remain owed.
Okay. Let me give a recap because this case is closed complied. Based on what the testimony and presentation by town attorney, there's a difference between the parties of about a week. But what the city has agreed to do in light of the small disparity, if you will, is they are extending the compliance date by 30 days, which would bring it to February
15th.
February 15th of 2025 as the compliance date, thereby including your representations that the property was in compliance during that time frame which makes this case also closed, complied. Administrative costs for this case haven't been paid. You do need to pay that. Did I get that?
Hold on, just to confirm, are administrative costs for today's hearing being included or are they being waived?
Right, it's being waived because they were in compliance
Correct.
prior
So
to
then
this
the
hearing.
only admin fine is the original from the first final order.
From the first final order back in September.
You have a moment, just strike this out
Okay.
and I'll be right back.
Okay, unless you have any questions, nothing further.
Question, thank you very much.
Okay. If you could step to the side, you will get a copy of the order. Just give us 1 second.
Sure. For this would also at this time complete the sign-in sheet that was given to us. Looking at the room, I believe we had 2 people walk in late and would still need to be sworn in. I believe this gentleman in the purple was sworn in. Were you sworn in, sir? Okay. So the 2 other young lady that walked in need to be sworn in, and then we can call their cases. Have they signed? Have you all signed in? Okay. Thank you. We can just call it. I mean, we don't.
Okay.
What cases? Yeah, it's fine.
I think these 2 in the front row were here prior.
The gentleman in the purple was here.
Okay. Which,
Yes. Yeah. We'll just. That's fine. Yeah, we just got to swear them in.
can you please raise your right hand? Well,
It's fine. We'll swear him in again.
Yes. Thank you. Do you swear and affirm that the testimony that you will provide would be the truth and nothing but the truth? Okay. Thank you.
Here, here, here. Do we have the? Which case are you here on, sir and ma'am?
8305.
8. Okay, what?
That one.
Okay. 8305, which is 10.2. Hearing to extend time. Eartha Wingham, 3911 Southwest 52nd Ave, 1 through 3, Pembroke Park. Madam Magistrate.
Yes.
So, section 10.2, please approach.
Perfect, thank you.
And please state your names for the record in relationship to the case. 765.
We're going to have the city present.
Right.
Morning, Eartha Wiggum.
He's going to present, and then you'll have an opportunity to respond. But your case is on for
Extension
of time.
Sorry. Code Officer Jeffrey Lewis for case number 8305. Address is 3911 Southwest 52nd Avenue. Building 3, Unit 1. For Eartha Wiggum, in regards to a notice of violation for a wooden canopy without a permit and a wooden fence. This notice of violation was first issued March 7th of 2023. Had a final order back in June 18th of 2024, and an extension of time, which is for today. In regards to being in compliance, the only outstanding issue is the fence. And is looking for an extension of time. The town recommendation for extension is 60 days for completion of the permit. The application is already in, and it is pending review as of 7/8/2025.
Good morning, Ms. Wiggum. I believe you introduced yourself and said you are the owner of the property. Your case is on for extension. The town is offering 60 days to come into compliance with that one missing or incomplete item, I should say. And then once that's taken care of and it's inspected and the permit is closed, the property, and then the town is notified, the officer, can comply the case on the closed out permit date. So it's 60 days.
But can you tell me how long it's gonna take? I spoke to Mr. Jeffrey just yesterday, and I've been calling, you know, after we submitted to zoning, the drawings. And, you know, it's just, I've been waiting.
When did you submit that?
It was submitted, I would say, 3.5 weeks ago by the contractor. He emailed it to, I called the town, and they told me where to have him email the drawings. And, you know, if I hadn't called in checking on it, I would have never known that it was denied by zoning. And then when they informed me what I had to do, and I said, oh my God, I gotta need some more time, so I came in, and,
But your contractor should have gotten that information.
yeah, well,
If-
I've been on him too.
Okay, yeah. That's,
I just want it over with.
I can only imagine. Any input, Officer Lewis, no one has a crystal ball. Let me just say that, town or otherwise, and everything.
They're just saying that it's pending, and I called the week before, and I spoke to Marta. She's been very nice, and she said, call me back in 2 days, which I did, and then yesterday I spoke to Mr. Jeffrey.
Correct.
And, you know, he said, just come back in for the hearing, you know, for the additional time, because I don't know how long it's gonna to say it's okay.
Right. It's been submitted back to review to zoning. We're just waiting for them to complete it. Most likely it'll be completed probably by Monday.
He won't promise.
That's what I'm hoping for.
Unless his fingers are crossed behind his back.
And that way that would go ahead and complete. They can receive their permit and then complete the project itself.
Okay, and your testimony is that the correction items have been submitted and it's been pending 3 weeks?
Yes.
Okay.
Sure. And Ms. McKinney, if I may just ask something to the record?
Yes.
So Ms. Wingham initially asked you if you could tell her how long it's going to take. So just for the record and for Ms. Wingham, just to say that the special magistrate's role is to listen to the evidence and testimony presented and then make a ruling based on that information. As far as her independent relationship with the town, she's the magistrate, and then that determination independently of us, so she wouldn't be able to answer the question, but she can of course have staff answer, which we did.
Okay.
Sure. Just to explain more the role, understand, so you can know so you can get your answers from the correct party. Sure.
Which is why I have to ask questions too, because I don't know. I'm hearing all of this the day of and everything, and which is why I ask certain questions just to have an idea. To hear all the evidence necessary for me to make a ruling. Okay, is there anything else from either side?
No.
Okay, what I'm going to do based on the testimony and evidence is I'm going to grant you 90 days, right? Now, you're almost there, and so with 90 days, you're going to have to stay on top of your professional who you hired and everything, because but for you having called the city, more time you could have lost more time. And so between you and your contractor or the professional that you hired, so 90 days. If nothing else from either side, I'll give oral pronouncement based on the testimony and evidence presented. There is substantial and competent evidence to approve the request for the extension of time. The respondent is ordered to come into compliance within 90 days. Failure to come into compliance and correct the violation will result in fines accruing on the property daily until the property is in compliance. Okay, you'll get a copy of the order, and good luck to you.
Thank you, Ms. Wingham.
You're welcome.
It would be the same. It would be the same that the final order. Officer Lewis.
It's an extension of time. The only thing that was modified was the compliance date. All remaining aspects of the prior order remain in place.
Staff's asking, so just want to.
Oh, okay. All right. The last case we have on the sign-in sheet is case 7.7 on your docket, case 10765, Margaret Edwards, 6816 Southwest 52nd Ave, Pembroke Park, Florida. Formal hearing, first offense for repairs and installations without a permit.
What happened to the gentleman in the purple shirt?
Yeah, he was here first.
Yeah.
Yeah.
Oh, okay, oh no, okay, I thought you were with Ms.
106.
Ringham. Okay, what case are you here on, or?
He's he's case 10622.
Okay, that's not here, my apologies. 10622 is,
First page. We just got sidetracked with case 8825, 8826,
Oh,
8885.
it's right here.
well, that was 725.
Yeah, he's been
My
here.
apologies.
Okay, case 7.5, 10622, Giorgio Manchetto. Macanecto, 3911 Southwest 52nd Avenue, 6-1 Pembroke Park. Formal hearing, first offense, repairs and installations without a permit.
George.
She was given 90 days, right?
Yes, Ms. Wiggum, yes.
Was approved last day. Good. Okay. Jeffrey Lewis, Code of Compliance Officer for the Town of Pembroke Park for case number 10622, located at 3911 Southwest 52nd Avenue, Building 1, Unit 6, for Giorgio Macanetto. I'm going to get it right one of these days. This is in regards to a notice of violation written for the installation of a new wooden fence, and this would need to be in compliance. Notice of violation was originally written February 5th, 2025, and this is the formal hearing of that. As of date, it has just been approved and can issue the permit, so he can go ahead and complete the work. And the town is recommending 60 days to give him time to complete the work and have the violation in compliance.
Or a per diem of?
Otherwise, a per diem of $100 per day.
Okay. Good morning, Mr. Macaneto. Okay. So the code officer, you've heard his testimony. It looks like you need a permit for the wooden fence, but the permit's been approved, so that's good. The town is giving you 60 days for the permit to be complied and closed out with. If not, a fine of $100 per day will start to add up. Okay? What's your position?
My contractor kind of moves slow.
Your-
My contractor moves very slow. I don't know. So
Oh.
now finally he's good now.
Oh, okay. Is 60 days going to be enough? Because once the fine, okay. Okay, very good. If nothing else by either side or pronouncement, based on the evidence and testimony presented, there is substantial and competent evidence to support the town's position that violations exist on the subject property. Respondent is ordered to come into compliance within 60 days or face a $100 per day daily fine that will continue to add up until the property is in compliance. You are also assessed $100 administrative cost for today's hearing. Good luck to you.
Just to add into the record, I apologize. The affidavit of service.
Thank you.
Thank you for your patience.
All right, so now we go back to 7.7, which will be the last case for the sign-in sheet. 10765, Margaret Edwards, 3816 Southwest 52nd Avenue, Pembroke Park. Formal hearing for repairs and installations without a permit.
Uh, 10765. One oh seven 65.
Say 7.7.
Apologize. 1 second here. The insult fence.
Ms. McKinney, if I may.
There we are.
Ma'am, can you state your name in relationship to the property?
Yes, of course. My name is Michelle Bantaken, and I'm the contractor for Ms. Edwards.
Okay.
You're here with permission of the owner to speak on the case?
I am.
Okay,
Thank you.
you're welcome.
Just in case, I do have electronically signed authorization letter.
Okay.
I'll just email it over to Mara or whoever.
Yes, you should.
Okay, absolutely.
Code Compliance Officer Jeffrey Lewis for case number 10765. This is for site address 3816 Southwest 52nd Avenue in Pembroke Park for Margaret Edwards. This is a violation, notice of violation for installation of a fence without a permit. The notice of violation was written back in March 20th of 2025, and it was given 30 days to be in compliance. Reinspection of the fence to show that it's still in violation. And yes, just as was stated, it was spoken with the contractor since July 2nd to get everything in compliance. The town is recommending 60 days to have this in compliance. Otherwise, it would be $100 per diem if not in compliance.
Okay. Once more, your name for the record, and your relation to the subject property, and if not the owner, your authority.
Michelle Benzigan, I'm the contractor for Miss Edwards, who's the owner of the property.
Okay. So it looks like this is a permit that needs to be procured, and the town is recommending 60 days in which to do that. To accrue, or the property, $100 daily fine.
I was hoping that I could request 90 days, please.
Okay. The objection on part of the city?
No objection.
Okay. Okay, if nothing else by either side, I'll give oral pronouncement. Based on the evidence and testimony presented, there is substantial competent evidence to support the town's position that violations exist on the subject property. The respondent is ordered to come into compliance within 90 days. Failure to come into compliance will result in a daily fine of $100 per day that will continue to add up until the property is in compliance, and the respondent is also assessed $100 for today's hearing. Good luck to your client.
Thank you. Do I get like a paper copy? Or
Yeah,
okay,
just give me a moment.
I'm waiting. No, absolutely. Thank you.
So, we want to go back?
The record.
Town attorney. Yep, once we're back on the record. Okay. Okay, we are back on the record.
All right, we're back on the record. Ms. McKinney, Madam Magistrate. We're going to start with, let me just see here, 10159. Well, on your docket, 10159, 10353, and 1404 were all announced as complied during the adoption of the modifications to the agenda. It is listed on there. So 7172 and 73, case 10159, case 10353, and 10404 are all being removed as complied.
Okay, very good.
That brings us to 10.1. That's case 7154, Saws Inc., 2690 South Park Road, Unit 10, Pembroke Park, Florida, hearing to extend time.
$7,154.
10.1 on the agenda. Is this it? Oh. Yes. You're welcome.
Code Compliance Officer. There we go. Sorry. Code Compliance Officer Jeffrey Lewis for the town of Pembroke Park for the case number 7154, which is located at 2690 South Park Road, Unit 10. This is in reference to a notice of violation for operating a business without a business tax receipt. In order to have compliance, they would need to obtain a business tax receipt and certificate of use. The notice of violation was originally written May 27, 2022. And the notice of violation was in place as of August 17th, 2022. This is for a hearing to extend the time in order to give them show that they're in compliance.
Okay. And the compliance date would be
7/11/2025.
Just want to confirm. Thank you, Officer Lewis. Case number 7154, property located at 2690 South Park Road. Anyone here on this case, seeing and hearing no one come forward. Based on the testimony and evidence presented, there is substantial and competent evidence to grant the extension of time. The respondents are ordered to come into compliance on or by July 11th, 2025. Failure to come to compliance will result in daily fines accruing on the subject property. Administrative costs are being assessed at $100. This is this case? Okay.
Oh, how much time?
15.
15.
All right, next case, 10.6. 311 Southwest 52nd Avenue, Building 2, Unit 8. This is a hearing to extend time.
Code Compliance Officer Jeffrey Lewis for the town of Pembroke Park, 9794, with the address of 3911 Southwest 52nd Avenue, Building 2, Unit 8, for Jean and Jolie Averill. This is in reference to a notice of violation, which was written on July 16, 2024, for the installation of a new wooden fence without a permit, and they would and also repairing of a dilapidated screen room to be in compliance. The notice of violation and formal hearing was done March 19th of 2025, and they are requesting an extension of time in order to be in compliance. They actually pulled the permit and has been in compliance with the fence, and they just recently completed the repair to the screen room as of June 12th, 2025. So therefore, if we do a extension of time for 15 days, it would go ahead and show that they are in compliance for the property.
Okay. Case number 9794, property located 3911 Southwest 52nd Avenue, Building 2, Unit 8. Anyone here on this case, seeing and hearing no one come forward, based on the testimony and evidence presented, there is substantial and competent evidence to support or approve a request for an extension of time. The respondents are hereby ordered to come into compliance within 50 days. Failure to come into compliance will result in fines accruing on the subject property. Until the property is in compliance, respondents also assessed $100 administrative costs. Next case, 15 days.
Case 10.8, case 10545, BDRC Pembroke Park LP, 3301 West Hallandale Beach Boulevard, Pembroke Park, Florida. Hearing to extend time.
10545.
Thank you.
Hold on, who?
BDRC, Pembroke, 10.8.
No, my apologies.
Yeah, I got it here.
Yes, you're correct. Sorry.
Code Compliance Officer Jeffrey Lewis for the Town of Pembroke Park, case number 10545, for the site address of 3301 West Hallandale Beach Boulevard for BDRC Pembroke Park LP. This is in regards to a notice of violation that was written for multiple snipe signs on the property and 2 sandwich signs, which are all prohibited by the town ordinance. The notice of violation was originally written January 22nd, 2025. A final order was given on March 19th of 2025. And it shows that they actually complied with this back in March 29th, 2025, within the time frame of their final order.
So will the town be announcing on the record, this
Yeah.
case is closed complied?
Yeah, that's what I wanted to confirm. So there's no order that has to be drafted. It's just that we were confirming their compliance.
Correct. So we are confirming that they are complied within the time frame of the final order.
Okay.
So therefore, the
case number-
case is complied.
Very good. Case number 10-545,
Right.
closed complied.
And my apologies, there should be an addition to the agenda. There was a last minute petition for an extension of time. It's case 9976, which is Darren Rudnick. You're well aware of our friend Rudnick?
Yep.
Yes, I know. The agenda will be modified to have the inclusion of the additional case.
If I may, is this at the respondent's request?
Yes.
Okay. With that, Madam Administrator, if you would amend the agenda.
Okay. The town is requesting amendment to add 9976 without objection. Case number 9976 is added to the agenda as a request for extension of time filed by the respondent.
And we will put this under 10.9.
Yeah.
So 10.9, case number 9976. Code Compliance Officer Jeffrey Lewis for the Town of Pembroke Park in regards to case number 9976 for the address of 2311 Southwest 30th Court. This is in regards to a notice of violation that was written back in August 5th of 2024 for outdoor storage of the premises, miscellaneous items on the outside of the premises that needed to be removed and complied. Blight damage to the enclosed addition, which for repairs that would need to be done. And also for a window that was installed without a permit. The final order was written back in November 20th of 2024, and they are requesting an extension of time in order to be in compliance. The only outstanding item is the installation of window. Everything else has been in compliance. So their recommendation is to give them 60 days to comply in order for them to pull the permit properly and close out this violation. If the
Oh, no, go ahead.
if the extension is not completed in 60 days, it would resume its final order amount of
I just want to clarify for the record, if we could, Madam Magistrate, if I may, that the respondent is requesting that this be put on the agenda for this hearing and understands, again, what I'm concerned with notice, and that their request is for 60 days, and that the town is in agreement with their request.
Correct.
Okay. Just want to put that on there so there's no issues as far as notice is concerned, given the fact that we're honoring the respondent's request.
Yeah, no, the petition also
Okay.
states that, they're waiving their right for notice in regards to petitioning for, because they petitioned yesterday for
Okay.
today's hearing.
Then if we're in agreement, then that's fine. I just wanted to make it clear for the record. Thank you.
Thank you, everyone. And the record reflects that the respondent petitioner who's asking for the extension, he is not here today. No one here on case number 9976-2311 Southwest 30th Court. Based on the testimony and the evidence presented, there is substantial and competent evidence to approve the request for extension of time. The respondent is ordered to come into compliance within 60 days. Failure to come into compliance will result in the fines accruing on the subject property. The only amendment is as to the time for compliance. All other respects of the final order remains intact. Respondent is also assessed $100 administrative costs for today's hearing. Anything else?
Nope.
No other business? Okay, we stand adjourned.
Thank you.
Time is 11:09.